everybody. This is such a great conference. Thank you for inviting me. And we've got a real cross-section of people here, which is one of the things that makes it really great. I suppose, wait, I need to know how to get the PowerPoint to change. Do I have to do it here? Okay. I have to step back and forth. Maybe I'll... Where's the click? Is there a clicker?
There you go. Yeah,
all right.
on the thing, your computer thing.
Okay. So my paper is called Queering Crimmigration, and I just thought since we're all kind of coming at this from different angles, I would just spend a few minutes giving you the lay of the land and some key background before I launch into my particular paper. So the first question is, what's crimmigration? About 15 years ago, people in the field of immigration law started talking about this increasing intersection of criminal law and immigration law. And then in 2006, a law professor named Juliet Stumpf coined the term crimmigration. It's kind of stuck, and it's now the framework. I think that a lot of writing and discussions of immigration are taking place within. So there's a number of different dimensions of crimmigration. I've got a few of them here. I'm just going to highlight a couple of them that are particularly relevant to what I'm going to be talking about. The first is the immigration consequences of crimes. So it has always been the case, or at least for decades and decades, that certain crimes might lead someone to be deported. But these days, that can happen even if it's a very minor crime, even if the person, in many cases, didn't serve any time in jail, even if the person's a lawful permanent resident, has been here for many years. So that connection has gotten much, much stronger than it used to be. So that's one element I want to highlight. The other is that the federal government is increasingly looking to local police for help in enforcing the immigration laws. And a lot of that's taking place through information sharing, database integration. Some of you may have heard of the Secure Communities program. So this is happening it's being automated. So someone gets stopped, a cop stops someone on suspicion of a crime, puts their name into a database to see if they have any warrants out for them. That information is being transmitted directly to Homeland Security these days, and then they can just come and pick the person up if they want. So, this is crimmigration in a nutshell, right? But the bottom line is that the local police and the county jails are increasingly serving as a pipeline into the detention and deportation system. Okay, so that's crimmigration, and there's a pretty widespread agreement about the timeline of it, which is that in retrospect, now knowing what we know now, if you look back, you can kind of see the initial rumblings of this in the late 80s. There's suddenly this new emphasis on immigration enforcement after a number of decades of kind of the liberalization of immigration laws. It all becomes about enforcement. In 1996, Congress passes two really big sweeping immigration laws that kind of really change the rules of the game, and then federal funding just goes through the roof, particularly post 9/11. So that's kind of the conventional view on the timeline, and so basically, sort of the crimmigration era is about 25 years old at this point. And I should say, there's great work happening on crimmigration, and I really value much of it. But I think that, and I include myself in this, I think we all sort of bought into a certain critique of crimmigration, which is basically immigration law and criminal law used to be separate. Now they're intertwined, and that's not a good thing. So I'm totally down with it's not a good thing part of that. But I think I'm not so down with the they used to be separate part of that. And that's really what this piece that I'm writing is about, is kind of trying to challenge that notion that there was some sort of golden age in which they were separate, and to kind of provide an alternative history of crimmigration and grapple with some of this. What got me started on this article is that I was looking at cases in which men where the INS was trying to deport men who had been arrested for some kind of sexual activity with other men in the 1950s and 60s. As many of you know, right, there was the local police departments in the 50s and 60s were really going after the queers. There were raids on gay bars and all these sting operations in public bathrooms and public parks. So lots of people, particularly gay men, were being arrested. And some of these people were not citizens, and some of them ended up in deportation proceedings. And some of you may know Margot Kennedy's work on this, which I'm a big fan of. She coined the great term "from bathrooms to borders," which really kind of sums it up. And but anyway, what struck me about these cases is how closely they fit the kind of contemporary crimmigration paradigm. Which is to say they involved lawful permanent residents who had very, very minor brushes with the law. These were not, we think of that era as being about, INS was going after, big name organized crime figures and stuff, but these are people who had, they weren't even doing any time in jail. These were disorderly conduct kind of offenses. They'd pay a $25 fine. So, And the other key thing was that people seemed to be going straight from the hands of police to the hands of the INS, which you don't see in a lot of other cases from that time, and I think is a really key kind of part of what we're seeing now. So, so this, these cases suggested to me kind of a different timeline that I think had been that the crimmigration literature hadn't really grappled with. So. I think it's certainly true that something new is happening now. This is so deportation comes into existence in 1892. There is no deportation before that. There's border control, but there's no mechanism for expelling people who are already physically present in the United States. So as you can see, right, so much of the 20th century, it's basically a very low, flat line. And then you get the last 20 years right there, it goes straight up. So there's definitely, I don't mean to suggest there isn't something new going on now, right? There certainly is, and it's certainly true that the laws have changed in very significant ways recently. But what I'm doing in this piece is looking at things from a different angle. I'm sort of trying to write a conceptual history of crimmigration. I'm looking at how policymakers in the federal government and at the state level have understood the relationship between the criminal justice system and the deportation system, which started way back at the beginning. And these, I think, this suggests a different timeline. I'm right in the middle of looking through the archival material right now and in fighting with the government about getting access to some of it. So my conclusions right now are quite tentative, but here's where I'm at so far. So the first thing is that very early in the deportation system, you see people starting to look to the prisons as sources of deportees. As I said, deportation doesn't really start till the 1890s, and it gets started slow. It's really the first couple of decades of the 20th century that this system comes into being, and all the way back in 1907, you have Congress passing this law telling the Commissioner of Immigration to look to the prisons to find deportees, prisons and other kinds of institutions. So let's see here, prisons, charitable institutions, public and private of the several states and territories. And the agency then turns around and does this. It establishes all these ties with all these various institutions around the country. And what you see over the next 3 decades or so in the archives is this very lively debate about the nature of this collaboration. So you get the federal immigration people complaining that the prison wardens aren't giving them enough information, like that, these are kind of political patronage jobs, these heads of these institutions and these prisons, and so that they're always turning over, and so the new people come in and they don't know how to any of the reporting procedures, so they're kind of falling down on the job. You get people at the state level, at the prison wardens, et cetera, complaining that they actually are sending all this information and that immigration isn't showing up to deport people. This is, to anyone who's been following the whole sort of Arizona dynamic, right? There's this familiar issue of, is the federal government doing enough to enforce the immigration laws? The state legislatures get into the act. A number of states pass laws requiring prison wardens, for example, to report any non-citizens to the Immigration Service. So, and this is, this kind of crops up again, like in 1934. There's this New York State puts out this report. It's actually authored by Harry Laughlin, who was a big eugenicist, and he was obviously saying we should deport everybody and they're defective and degenerate and whatever. And so the whole tone of the report, he surveys all these institutions, though, and they all say that they're doing a great job of reporting and immigration isn't doing its job. And so it's very critical of the federal government. And then, so the Immigration Service turns around and then surveys all of its district offices and says, well, what are you doing, about this? And so here's, this is from, let's see here. So there's this 1936 memo about the survey that says, we're doing all this stuff. So of the 22 immigration districts, 17 reported routine checks of all penal institutions and state asylums. Some districts' checks were made as often as once a week. 4 remaining districts report, the math doesn't work out right, but there's one district that didn't, if you're worried about that. There is one district that didn't send in a response. Hawaii didn't send in a response. The 4 remaining districts report that they have excellent cooperation from state authorities in their districts in the matter of reporting alien inmates in state institutions. Okay, so for starters, I think we can see there was no golden age when these two systems were separate. The funding and the infrastructure may not have been in place, but the desire to knit these two systems together runs very deep, and it's something I think we need to grapple with. And I say this not just as someone who writes about this, but as an advocate. I think this is the advocacy narrative has also been very much kind of Congress took a wrong turn in the 90s. We need to kind of go back, and I think it's more complicated than that. So that's part of what I'm trying to argue. The other part, though, is and this gets me to the 1950s cases, is I think there was a crucial shift that occurred in the 1950s to put us on the path we're on today. And that these cases involving gay men kind of give us a window into that shift. So let me talk to you a little bit about these cases. So the early approach, right, that I've just been talking about, looked to prisons, but it looked to prisons and hospitals and mental health facilities and almshouses, right, the poorhouse. It looked to all these places where there were immigrants who were living, who were not self-supporting, right, who were costing the government money or costing private charitable institutions money. And it was really within this framework of who was a public charge. That's always been a big issue in immigration law. And so it wasn't specifically about the prisons, right? It was under this very different kind of framework. And these cases from the 50s and 60s, though, these gay men, they really don't fit that pattern. These were lawful permanent residents who had jobs and weren't in prison at all, right? They just kind of passed through the hands of the police, and it's a very different setup. And so here's a couple of examples. Here's one. This is a lawful permanent resident from Canada. There's actually a lot of them are Canadian. I have some theories about why that might be. But so they're and the Detroit police actually, I think, were particularly enthusiastic about collaborating with the INS, so that may be part of it. But this guy was arrested in Michigan for soliciting for an immoral act. He was convicted, but then found not guilty after a new trial. Following the arrest, the respondent was questioned by the service, that's the Immigration Service, and examined by the United States Public Health Service psychiatric consultant. And found to have psychopathic personality disorder. So that's just a little side note here, that actually, so people who were being deported for being gay, most of these guys didn't have actual convictions that rose to the level that would justify deportation. So they were actually being found by the police, but the grounds of their deportation had to do with the fact that being gay, homosexuality was a separate ground in which someone could be deported, but it was this very medical model of it was widely understood to include homosexuality, but the term was psychopathic personality disorder, and so in order for someone to be deported under that, they had to be someone from the U.S. Public Health Service had to certify that this person actually was in that category, just like anyone who had a contagious disease or whatever. So. And then, all right, I'll give you another example, also an LPR, also a lawful permanent resident, also from Canada, arrested on December 13th, 1954 by the Detroit police for investigation in connection with a larceny charge. The charge was subsequently dropped, but he apparently admitted that he consorted with homosexuals And then he made this a statement to the Immigration Service on December 16th, 1954, regarding his homosexual tendencies, and so then he ends up in deportation proceedings. And these cases, the challenge is these cases don't tell you how this process happened, right? I'm sort of having to read between the lines a little bit. I don't say how the information got transferred or what was going on in terms of infrastructure, but I think there's a very strong inference in these cases when someone's arrested by the police on December 13th and then questioned by immigration on December 16th, that these were kind of linked, right? Because you have a lot of other cases. I mean, the standard cases from the 30s, 40s, even 50s are people who are being deported, and it turns out, 15 years ago, like 1925, the person was convicted for something or other, and then they've somehow come to the attention of immigration through some other way. Like they leave the country and they come back, or they apply for citizenship or something. And these just don't look like that. It's really clear that, or it seems quite, there's a very strong suggestion that they are going straight to the hands of immigration. Okay, and then there's the case of George Flutie. This is what kind of got me into this, because I've always been fascinated by George Flutie. This is a big case. His case went all the way to the Supreme Court. There's something called the Flutie Doctrine, and my one else who are here, you'll learn about it when you take immigration from me next summer. So this is a well-known case in immigration for some reasons that have nothing to do with any of this. But I was always interested in the backstory. So this is this guy. He was a lawful permanent resident from Switzerland, came here in 1952, and worked at a fancy hotel in Southern California. And he was arrested several times in the mid-50s in Los Angeles for, gay-related things. I mean, he was charged with being a lewd person at one point with disorderly conduct and whatever. Basically, he was arrested in public parks. He got the final conviction. The final arrest was in November of 1958, and then 4 months later, in March of 1959, an INS investigator comes knocking on his door. The arrest didn't result in any jail time or anything, so he's living his life. The investigator shows up at his door and interviews him, and gets a statement from him, a sworn statement. And none of this is in the official decision, right? But if you look at the statement, it says something that I find very interesting. So here's what Flutie says when they come and they interview. He's got no lawyer there or anything, right? He tells them everything they need to know to deport him, basically. And he says, ever since that second arrest in Los Angeles, I have felt that the United States immigration might be looking for me because I heard that such things were reported to Washington. So I have been very careful. Now, it's basically in this piece I'm arguing that Flutie's statement really marks this important shift. That Crimmigration scholars really should attend to, because no one would have said that before the 1950s. And I'm not sure that anyone who wasn't gay would have said that in the 1950s. I mean, it's hard to know exactly what Flutie was thinking, right? We can only speculate. But I think the most obvious explanation is not that he knew anything particular about immigration enforcement, but that this was a reference to the Lavender Scare, because I think that was widely known at the time. So this is familiar with it, but there was a purge of gay and lesbian employees in the federal government in the 1950s, and the FBI in the early 50s established very strong ties with vice squads all around the country, and was getting arrest records of every single person who was being arrested for anything that was gay-related, so that those people could be fired from their government jobs as security risks, right? And that was widely known. I think that, for a gay man in the 1950s to think that one's prints were being sent to Washington is, that makes perfect sense, right? That he would have thought that. I think this really represents the fingerprint file. The FBI had a fingerprint file starting in 1924. I mean, just sort of to be a resource to police or something, that kind of fingerprint file. But this is the first time. I think the Lavender Scare is a totally new phenomenon. This was the first time that the federal government systematically collected arrest data to use for non-criminal purposes, right? As just sort of a screening device. And and the degree of over-policing of gay communities in the 1950s made that data a very useful source, right? I mean, I've seen estimates that like 20% of gay men in the 50s had been arrested, for example. So when you get that level of police involvement, then the records of police become very useful. So, if you fast forward to the present and think about secure communities or all this sort of information sharing and this use of the police, right, for immigration purposes, I mean, now, post-war on drugs and war on crime, I mean, if you look at the rates of arrest and of sort of police surveillance of young men of color, for example, who are the primary targets of the deportation of the Crimmigration regime as well, I mean, they far exceed 20%, right? The most recent data I've seen was, I think, by age 23, 49% of black men have been arrested, almost that many Latinos. I mean, this is kind of, I feel like this is, in some ways, this 1950s sort of focus on these gay men was kind of the rehearsal in some ways. I don't mean to suggest that there was a direct line necessarily, but this is the first time you see these kind of techniques being tried out, and this use, there had always been this desire to knit these two systems together, but they get knit together in a totally different way in the 50s that I think has a lot of resonance as we think about crimmigration today. So I guess I'll leave it at that, and we can talk more in the conversation.